Goldberg v. Kelly inaugurated a new time in American constitutional adjudication. It was not only the first case that dealt with social welfare and the way in which it was protected as a right by courts, but also it was a response to the so-called war on poverty, predicated by judicial adjudication. Even though that the case was adjudicated in the early 70s, it initiated in the half of the decade of the 60s, coinciding with Lyndon B. Johnson war on poverty that was continued by President Richard Nixon. Poverty increased dramatically in the United States in the post-war, considering that the war economy increased for almost 15 years after the end of the Allied victory in Europe. In the half 60s, they start dealing with increasing number of poor communities surrounding the urban settings of different states. Therefore, the state that was also growing not only in number but in power due to what we have referred here as government by numbers, as described by Bruce Ackerman, the state deemed all this crisis as a result of failed economic policies. Therefore, they triggered a series of shock policies that aimed at providing basic welfare to those people not only in poverty but in economic need, considering the difference between those concepts. And that was the genesis of Goldberg v. Kelly, because Goldberg v. Kelly involved a federal and a state program to fight poverty. And the key point of our case for today is if welfare benefits are entitlements of constitutional protection or not. So I think that is one of the main points that I would like to address for today's discussion. There are a few concepts that I would like you to bear in mind, such as injunction, such as notice, such as class, such as class representative, such as pre-termination hearing and post-termination hearing. Those comprise our basic grammar for Goldberg v. Kelly. So now I would like us to bear in mind that this is the beginning of the Burger Court. Therefore, the Gilded Age Court, the Warren Court, is waning. The liberal bloc is also losing influence and power in the decision-making process. So here we will see Brennan giving one of his last fights, and he took it very seriously. In the opposing view in Goldberg, we will find the senior member of the court, Justice Hugo Black, and Hugo Black presents a reading or an understanding of welfare benefits that collides completely, not only with Brennan's view, but with the legacy of the New Deal as a constitutional moment. So remember that the New Deal inaugurated a new understanding not only of the Constitution, but also of the so-called social rights in the United States and the power of the executive branch to making them effective. So in that context, we will see that Hugo Black, notwithstanding the fact that he was nominated for the court in the immediate post-New Deal era, he is an adamant critic of welfare benefits. So in this particular case, we will find the dissenting opinion in some parts much more clarifying than the majority opinion itself. Goldberg v. Kelly fits into a larger spectrum of what we borrow from Owen Fisk's article on the forms of justice as structural litigation, in contrast with the traditional model of litigation. I have described earlier how these two models operate. They are opposites in all regards. The traditional model of litigation, which we can deem also as the conventional model, implies applies the very well-known procedural triangle in which two neighbors that are unable to bring peace to their conflict go to a neutral third decision maker in order to pacify their dispute. So in this particular model of litigation, both parties are considered in a balanced situation in equal terms. So in this instance, the judge is not required to intervene much more than what the case requires by itself, meaning that the judge has not to bring balance to an original asymmetry between the parties, which is the characteristic feature of the opposing model of structural litigation, in which we'll find unbalanced parties. Most of the time is an individual against a corporation or a governmental institution, and due to that inherent or original asymmetry, the judge is not only expected to adjudicate but also to balance. And in terms of the FIS narrative of procedure and fairness, the judge is not only the adjudicator, the key decision maker, but the champion of the disadvantaged party by this overwhelming structure that is shadowing it in all possible terms, not only financing the litigation, but also in terms of making effective the very adjudication. So with that theory in mind, Goldberg v. Kelly fits in the thesis of a structural litigation of those that are trying to challenge unjustified, unfair intervention of the government in terminating their welfare benefits. And it will introduce a concept that until Goldberg v. Kelly had an instrumental nature. I am referring to due process of law as enshrined in the 14th Amendment. Until Goldberg v. Kelly, due process was seen as an instrument to make effective other rights. From Goldberg v. Kelly on, due process acquired what is called the substantive nature of due process because it related or equalized due process with fairness, meaning that due process as provided in the 14th Amendment is not only an instrument to make effective other rights, but it is a right by itself. But the point is that the vantage point of substantive fairness means that it is an equally fundamental right as freedom of speech or freedom to contract or freedom to associate. So Goldberg v. Kelly, let's say that upgrades the nature of due process for this expression of substantive fairness. Because as a bottom line in the present cases and also as a synthesis of the facts of the case, we are dealing here with both state and federal programs that involve welfare benefits that are financed exclusively by federal funds provided by a program administered by the HEW, Home and Education Welfare Department, that are allocated with local authorities in order to be assigned or dispersed. With that in mind, we have a class of individuals that were terminated of their benefits without notice. And because they didn't get notice, they were not able to have a hearing in order to prevent the apparent arbitrary termination of their welfare benefits. The point, in simple terms, was that all the beneficiaries or all the recipients, how did they know that their benefits were terminated? When they didn't get their check, they knew that the benefits were terminated. So here the point, because we will enter into the analysis of the process or the procedure to be precise, the point was that their benefits were terminated by denying their due process of law from a substantive point of view, because they didn't have a chance to have their mirroring the judicial process their day in court. They were denied the opportunity to be heard according to the procedure by the social worker or his his or her supervisor on the reasons for terminating those benefits. So in this case, is as simple as that we are before an act from the administering authority denying the rights of those recipients to continue receiving their benefits.